Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to inform the public, so please subscribe to our channel. Today we're going to talk about prior acquired property versus marital property. In other words, if you own something before the marriage and there's a divorce, is your ex entitled to any of what you had prior? Now, the general rule is that when we deal with divorces, the subject matter of what we are dividing are the marital assets, as distinct from separate property, those assets which were not accumulated during the marriage. But there are some exceptions, and so it bears looking into. First of all, you have to understand that the classification of something as non-marital doesn't etch it in stone as non-marital. Something can have the quality of a non-marital item but become a marital item based on the conduct of the parties. So for example, let's say you get married and before you got married you had a bank account in it in your own name and had $100,000 in it. That $100,000 is non-marital. Why is it non-marital? Because you accumulated from your blood, sweat, and tears before the marriage. But if you were to take that account, pull that money out, write yourself a check and put it in a new account in the name of the newlyweds, you and your new spouse, all of a sudden what you've done is you've changed the character of that item. You've changed it from a non-marital separate item to a piece of marital asset. You've gifted it to the marriage, so to speak. You've changed it so that instead of you owning 100,000 of those dollars, you now own 50,000 and she owns the other 50,000. So you've altered the character of it. That can happen, so you have to watch for that. Another thing you've got to watch for as we talk about this is sometimes there are items, the corpus of which are separate, but they increase in value. They develop dividends and interest and stuff like that. And then there's a question of whether or not the increased value of the item, whether that's in play. In the same scenario, with your blood, sweat, and tears, you got that $100,000. Even if you left it separate, that $100,000 is certainly going to be yours. It was separate property, you earned it before, you get married 10 years later, that money's still yours. But if that $100,000 on the day of the marriage is now worth $120,000 on the day of the divorce, it can be convincingly argued that that 20 grew during the marriage, and therefore that 20 is subject to division. If the court were to take that position on it, and most will, what you have there is 100 and 10,000 of it would go to you, and 10,000 would go to your spouse, because the 100 was yours before, and we're only splitting the 20. In other words, the notion of marital property versus non-marital property goes a little bit beyond just saying, well, when was it accumulated? It's not a question of only when it is accumulated, it's a question of when was it accumulated and what was the value then? What is the value now? And also, the question could be, have we changed the nature of it, in a sense, commingled it into marital property? If you have any questions about your marital property, reach out and we'll be glad to help you out.